Hey, welcome everybody, and thank you for joining us here today for this webinar discussion of, well, I'm not sure what we're going to call it. This is going to be a very wide-ranging conversation, a little bit political, a little bit legal, and it's going to revolve around the P tab. It's going to revolve around government. It's going to revolve around, by its very nature, some politics, not with I think the big P politics, but the little P politics that allows government to actually work. And maybe we'll get a look behind the scenes of what actually happens at an agency during transitions and so forth. And then I think we're going to talk about a mess that the Supreme Court created for themselves when they decided the first Arthrex decision, amidst all this political whirlwind. So on tap really is a conversation about the Federal Vacancies Act, and whether or not the Supreme Court should hear Arthrex 2. Again, that's sort of the overarching question we're going to act. They're being asked to do that, and we're going to answer that question the best that we can, and we're going to get to as many questions as we can that you have. We have Renee here with us to introduce the panelists. So Renee, take it away, please.
Sure thing. So you have a great panel today. So we're going to start with the top. We've got Robert Cry. He is a founding partner of Moeller Lamkin, where his practice focuses on trial and appellate litigation before the Supreme Court, federal courts of appeal, and other federal and state courts. His practice covers a broad array of subject matters, including sovereign immunity, arbitration, enforcement and arbitral awards, constitutional law, business litigation, securities fraud, and intellectual property. Prior to joining this firm, he spent several years in the Supreme Court and appeals practice at another prominent firm. He also served as a law clerk to Justice Antonin Scalia of the Supreme Court and Judge Alex Kozinski of the U.S. Court of Appeals for the Ninth Circuit. Next, we have Joseph Mattal. He's currently a partner at Hayes and Boone, LLP, where his practice focuses on the USPTO post-issuance proceedings and Federal Circuit appeals. He has served as both the USPTO's acting director and acting solicitor, where as acting solicitor, he defended the agency in IP cases before the Federal Circuit and Supreme Court. Previously, Joe served in senior legal roles for more than a decade for both the U.S. Senate Judiciary Committee and advised the U.S. Solicitor General's Office in key IP cases before the Supreme Court. And finally, we have our moderator, and last but not least, Gene Quinn. He's a patent attorney and a leading commenter on patent law and innovation policy. He founded IP Watchdog in 1999, and since has twice been named one of the top 50 most influential people in IP, and has repeatedly been recognized as one of the top IP strategists in the world. So you're in great hands with this panel. Take it away, Gene.
Great. Thanks a lot, Renee. And I smiled as Renee introduced you, Joe, as a former acting director. And that really, I think, sort of encapsulates exactly what it is that we want to talk about here today. Because if we were going to go with the patent office's preferred title that you had, it's sort of a paragraph long title that leverages the terms performing the duties and functions of some Senate confirmed office. And therein lies the problem. Maybe we start with you, and I don't want to pigeonhole your initial thoughts. So before I ask any specific questions, I'll just throw it out to you to get your general thoughts on this topic. And then maybe we'll put a pin in that title and come back to that and why that is sort of the piece that we need, the layers of the onion that needs to be particularly peeled. What say you with respect to your thoughts on this topic, generally speaking?
It's an interesting issue. I mean, there really is this tension between letting the federal government operate, especially during the transition between administrations, and having agency leadership that's accountable to the Senate, the constitutional structure. And the Congress thought about readjusting that, through the FVRA in the 90s, when there was this kind of push to rein in the executive a bit more. The question is whether they really did it, or whether they kind of looked over the cliff and pulled back and passed a statute that doesn't really do a lot, which is the Federal Circuit's interpretation and the U.S. government's interpretation. It's a real issue, the Constitution has this structure where you wanted agencies run by people who got sign off from the Senate, are accountable to them. And it does make a difference, when someone's Senate confirmed, they do tend to, feel beholden to the Senate and, this is who I answer to, et cetera. Obviously, you just don't get that when you're acting, and you've never gone through that kind of a process. But, Gene, why don't we have Robert describe exactly how the FVRA works and like who's allowed to be appointed under the FVRA, just for kind of.
Yeah, I think that's a good idea. Robert, let's first get your general thoughts. If you have any general thoughts on this from 20,000 feet, and then we can get into getting Arthrex point of view here. But so without any pigeonholes or specific directions, say whatever it is that you want to say to kick us off, and then we can go from there.
Yeah, so as Joe mentioned, there is a practical question about how to keep the government running, especially after a presidential transition where a lot of senior leadership may have resigned from office. And for the past 150 years or so, Congress has passed various statutes that have allowed non-Senate confirmed individuals to perform the duties of a principal Senate confirmed office on a temporary basis while the government goes about the business of confirming permanent employees. The latest iteration of those statutes was the Federal Vacancies Reform Act that you mentioned, and that's been on the books for about 25 years now. And it sets out 3 specific ways to do that. What it says is if there is a vacancy in a Senate confirmed office, that office's functions can be performed by either the first assistant to that officer, that's the default choice, or the 2 other ones are the president can put in office temporarily some other Senate confirmed officer, or the 3rd option is that the president personally can put in office a senior employee at that same agency, a senior inferior officer at that same agency who has a certain pay grade. And so those are the statutory officer options for appointing acting officers as such. The issue that is at the core of this latest Arthrex case is whether those options are exclusive, because for many years before the Federal Vacancies Reform Act and even after that statute, many agencies throughout governments have gone beyond those options and created their own schemes by regulation for keeping the agency running that don't require the government to follow one of those 3 options. And so the Patent Office's organization order is not unique. Many other agencies have orders like this, but what it does is it uses the agency's delegation authority to transfer administratively the functions of the head of the office to somebody else during a vacancy. And because most agencies have very broad statutory authority to delegate functions and duties within the office, this actually, on the government's view, allows them to accomplish the same thing as the statute, but without having to go through one of these 3 statutory options. And so this case with the PTO comes about because right after the presidential transition, the director of the PTO resigned, the deputy director of the PTO resigned. And so you had a vacancy at the top of the office. The first assistant office was vacant because that official had resigned too. For whatever reason, the executive branch didn't want the president to personally select someone to stand in. And so the PTO, though, has a standing regulation that says when those top 2 offices are vacant, there's another career civil servant, in this case, the commissioner for patents, who has authority to run the office during that vacancy. And so in this case, that was, Drew Hirschfeld, who was an inferior officer, not Senate confirmed. And he basically exercised authority under this regulatory delegation for about 15 months until finally Congress confirmed Kathy Vidal to serve as the permanent director of the Patent and Trademark Office. And so the core of Arthrex's latest challenge here is whether the Federal Vacancies Reform Act allows agencies to do that, or whether the 3 statutory options set forth in the statute for designating actual acting officers is exclusive. And this has been a contentious issue, not only since the FVRA was passed, but even in the decades before that.
So, I think Robert was a little kind there in giving the government the benefit of the doubt here. So I'll play the bad guy here. So what I was showing you first, let me just go back 2 screens. So this is the core of the act, the 5 USC 3345, which sets out the 3 instances, A1, 2, and 3, under which somebody can actually have the title acting officer. And the first one is if the person is the first assistant. Now, in the situation dealing with the patent office, that is rarely going to wind up being the case, certainly not at the end of an administration, the beginning of a new administration, because political appointees, they resign at the end of the president's term. So that's where you wind up very frequently getting both the deputy director and the director missing from the patent office, for example, and not only the patent office, but pretty much all agencies, the political appointees resign. And then, so the question is, does that then leave the only other ways that somebody can become acting as A2 and A3? And if it does, then it would seem as if the office came up with their own A4, which doesn't really fit, and didn't really give, for example, Joe the title of acting, but gave him the title and say, well, we're not going to call you acting, but we're going to say that you have the right to perform the duties and functions of that now vacant office. And then the reason that they do that is they don't want somebody to be acting necessarily, even though they might be able to, or they could designate particular people as acting, because you're only allowed to be acting for no longer than 210 days. Now, that sort of sets the dilemma from the offices, not only the offices, but overall the government's point of view. Now, Joe, just to put some context into perspective for people who are, maybe not familiar with the intricacies of how government works, we talked about this previously. This was not, the 210-day limitation was really not an issue prior to, and it's been on the books for a long time, but it wasn't really an issue prior to the Obama administration. And it seemed like everybody during that point in time was like the czars. That's when I think the czar, or maybe it was the end of the Bush administration, during the Bush administration, when the czars became of issue or concern. That's when this started to bubble up. I guess that was the Bush administration, maybe not the Obama administration. And then certainly during the Obama administration, you started looking at people saying, well, how long have you been acting? And is it too long? Do we need to move past you? Because we know people who have been acting in other situations prior to this becoming an issue. They were acting for a year or more. Like Drew was in charge of the patent office for more than a year, but he wasn't, quote unquote, acting.
Yeah, I guess it's a Clinton era statute, and I think it was in the, just going back to like the 1960s, it's just taken longer and longer to get people confirmed. The process has become, more contentious, more thorough background checks, more political opposition, et cetera. And yeah, you had some long running actings who had actually been, I believe, rejected, by the Senate, or the Senate had refused to act on him, and they were put in an acting role doing the exact same job. And people in the Senate decided, this doesn't make any sense. And that seems to have been the genesis of the FVRA.
Yeah. And it's interesting because we need to have somebody who's in charge of the office and running the office. And this would be an interesting continuity of government question, probably an interesting law professor kind of fact pattern, something that would get people interested, perhaps, maybe over a cocktail or something like that. But then we have the Supreme Court, specifically in Arthrex 1. I think the way I read the decision, I'll just speak for myself, and maybe you all can give your thoughts on this. The way I read the decision was they said that what saves these unconstitutional APJs is that you have a constitutionally appointed and confirmed officer at the patent office who can review their work. So as long as that's possible, then the way that the scheme is set up is okay. So then the Supreme Court, and they go on page after page talking about how they don't have to undo all this because it seems like that solves all the problems, because there is a constitutional officer in charge. Okay, whether you buy that or not, it is what it is. So then the remedy becomes, well, let's remand this to the, and they use the term acting director. And as we talked about, and Robert, maybe you can go a little bit more in depth into this, but the acting director is not always somebody who's constitutionally been nominated and confirmed in the same way. As I understand it, deputy directors are not always confirmed and haven't been confirmed for years. And then you also have the problem that during the time when Arthrex was going back up, there was no acting director, right? Have I capsulated this kind of, we take it from sort of like an interesting law school fact pattern or a law review article into like, what the hell did the Supreme Court create for themselves kind of a problem, Robert?
Yeah. So, acting directors or acting agency heads very typically are not Senate confirmed officers. One of the three statutory options is to have a non-Senate confirmed officer, as long as it's an inferior officer of sufficient pay grade within the agency. So that's not abnormal. And as I mentioned, since the 19th century or even earlier, this idea that you can have people performing what would be principal officer duties without Senate confirmation being okay, as long as it's done on just a temporary basis. Even within the patent office too, of course, the director is a Senate confirmed position. The deputy director is not. So even under that first option, under the FVRA, you're often going to have non-Senate confirmed people. So even though the Supreme Court in the first Arthrex case was discussing a general rule that requires Senate confirmed people to be exercising those kinds of powers, it was also deciding the case against a backdrop where there's a very lengthy tradition of having non-Senate confirmed people do those functions temporarily. The one real caveat to that, though, is that has always been understood to be required to be within the bounds of what Congress has set. So these 19th century statutes, Congress was precise about who could perform those functions, about how long. And so, the question in this case is Congress, having set those bounds in the FVRA, can agencies go beyond that and put people in charge, even though they don't comply with what Congress set up as the rules for when they're going to temporarily dispense with Senate confirmation. And the rules are not particularly restrictive. As we mentioned, there's three different categories of people who can serve as formal acting officers: either the first assistant, another Senate confirmed officer, or any one of several people within the agency that have a sufficient pay grade. And for those last two options, the only requirement is that the president has to personally select that person. That wasn't done here for whatever reason. The time limits too, you mentioned 210 days, that gets extended if there's a nomination to the permanent position. It gets extended under the statute if there's a presidential transition. So that's objectively, it's a very generous deadline, no matter how you slice it. So you would think.
So Joe, listen to Robert talk about that, it getting extended and so forth. I mean, and you don't have to answer this, I know, but so I'll just say it to myself, I'll ask it out loud. It's sort of rhetorical. Is it unrealistic for us as Americans to assume that the president will at least nominate somebody with 210 days? I would think no. I mean, for crying out loud, and then put on your hat for a moment. I know you spent a lot of years as you were the chief lawyer on the Judiciary Committee for a while, right? Or you were certainly Senator Kyle's right-hand man for a long time. And so the Senate perspective, right? It looks and feels to me like increasingly over time, this is just an effort by both parties. Both parties are equally indictable on this. Just trying to run government without having to go through Congress, at least in certain areas. They go through Congress in the high profile area, defense and state, where their nominees are going to get confirmed the day that they take office. But in some of these other, and unfortunately we work in an area where people don't get confirmed for a year or more.
Yeah, I have to admit the FVRA's time limit seemed perfectly reasonable. I was just kind of running the math against my own time there. I was appointed by the Commerce Secretary, they just, PTO is a subcabinet agency. You don't bother the president, with agencies at that level. And but if I had been picked by the president, I would have fallen into that third category, in the FVRA. I was actually there for 8 months. The time limit is 7 months, but the time limit is extended when someone's nominated. So it wouldn't affect me. I think the biggest challenge Robert's going to face with this argument is that if he wins, it applies retroactively, and all these government actions, are wiped out. Basically,
we do have a different view on that. This came up during the Federal Circuit argument in the case, and
Can you set up the argument, Robert? Because just so everybody, because I think, Joe, you're alluding to the fact that that would also call into question the patents that were signed to. Is that where you're going with that?
I don't know how far it goes, but if you didn't have anyone who could exercise those functions, it's just a lot that the head of the patent office does that is called into question at the very least if if these duties can't be delegated. So
Robert, go ahead.
Yeah, so with respect to prior actions of the agency, and this is the hundreds of thousands of patents that Commissioner Hirschfeld signed off on while he was in office, our response to that and what we had argued in the Federal Circuit has always been that there are a number of doctrines that restrict remedies, even if there's been a technical noncompliance with the FVRA. And so the de facto officer doctrine is the big one. That's the doctrine that says that if somebody who is acting in the office but is later found not to have been properly appointed to that office takes an action, and that action is not still on direct review at the time, then you generally can't collaterally attack it after the fact based on a defect in the person's appointment. And so it seems to us that in the case of patent issuances, that's almost always going to be the case, because of course normally there's not a direct appeal from a patent grant as such. And so and if people try and challenge previously issued patents in subsequent proceedings later, there's going to be a strong argument that those are protected by the de facto officer doctrine.
So it has to be something that's in the pipeline, basically, that's still under review somehow.
Still on direct review.
Okay. So you would wipe out probably hundreds of PTAB decisions, right?
Well, but again, they have to.
I'd be okay with that.
In the pipe, they still have to be on direct review, and the arguments have to have been preserved below, because outside that context, there's serious de facto officer doctrine issues.
Any rough estimate of how many PTAB proceedings would be affected if if the rule were applied that way?
I don't think it'd be a lot, would it? I don't think a lot of people have made this argument.
I haven't run the numbers on it.
Okay.
Oh. Yeah. No, but So, and I also think, and this is going to be very non-legalese, but for a court, and meaning the Supreme Court, that does an awful lot of very non-legalese things with a lot of hand waving when it suits them. I just feel down to my bones that there is a difference between a machine affecting a stamp or a signature or an image of somebody's signature onto a document that they had absolutely nothing to do with deciding whether to issue, or whether or not it is something as important as the director review. And important in that, look, I'll get to the counter argument. I'll argue against myself here in a minute, but as important as what the Supreme Court said it was. They pulled out American apple pie and American flag, and this works because we have somebody in there that's constitutionally appointed, wink, wink, nod, nod, even though we know that that's almost half the time isn't true, but they made this sound like all these unconstitutional officers are suddenly going to be, their actions are going to be saved in this very clever legal maneuver because of that, and it's like, these two, like on a Sesame Street level, you could have children come in and say, which one of these things is different? And I think that they would get that the order of magnitude is different there. And I mean, it's not to say that the Supreme Court would get that. I understand that. But because there's no legal there's not a legal argument I'm making there. Now, and I'm probably just sinking myself here, I guess, but it was so much of this stuff. It feels like what they're doing. And I guess this is where I'm going with what I'm trying to say. It feels like it's ad hoc, it's post hoc, right? You know, it's like we're deciding what we want to do, and then we're going to work our way backwards. You know, we have a comment or question on that from Kip, and he says, Scott McCown always says that these big IPR challenges never go anywhere. And there's a lot of political and institutional inertia to just leave IPR undisturbed. I think that's true. I think that, you know, it's like trying to make an aircraft carrier turn on a dime.
You know, I don't think the justices spend a lot of time worrying about, you know, the IPR system in particular. I think they're just doing this out of conviction that, you know, this is what the Constitution requires. And we're living through this kind of interesting era where the court has shifted quite a bit to the right. And, you know, all these constitutional provisions. This came up in our discussion earlier. I feel like my 1990s constitutional education from law school is somewhat useless. You know, I learned the Constitution is everything comes with a little asterisk. You know, this limit on structural power was really voided by the Supreme Court in the 1940s, and, you know, this thing can't be taken seriously. And suddenly we have this Supreme Court that takes all of those, you know, structural limits on the federal government quite seriously. And things that were, you know, when the AIA was enacted, the law was pretty clear that you could, you know, have 3-member rehearing, for example. That was still enough accountability. And you just have a court that is revisiting all these questions and often, you know, isn't terribly interested in the, you know, decisions from the 70s and 80s, you know, that weaken some of these doctrines.
It frustrates me because in one respect, you're totally correct. But in another respect, you know, like, so like the court has moved more conservative. I think there's probably no doubt in that, except for where it comes to property rights. Where it comes to property rights, the court has gone the other way. You know, I mean, like not to go totally go off the rails, but, you know, like if you look at eminent domain, I mean, there's no support in any of the Supreme Court's eminent domain rulings over the last say 15 years for anything historic. I mean, they're saying, oh yeah, we needed your property because it would have been better off as a mall instead of your house, you know? Okay, well, I mean, I understand, but that strikes me as it's a legislative decision, not judges calling balls and strikes. And then, where it starts, let me just get this out of the throat to you. And when it starts with eminent domain weakening, was it a shock to anybody that patents were eventually going to wind up as a government franchise? And I know that people say, oh, well, it's only a government franchise in this one little area. And I'm like, yeah, does anybody seriously think the Supreme Court said it's a government franchise in this area in oil states? And the next time it comes up that they're going to say, oh, no, in this totally different context, it's not a government franchise. It's real property here.
I do think if Congress passed a law that, for example, like voided patent rights retroactively or limited your remedies, you know, remedy as part of the property right, I'm pretty sure this court would say it's unconstitutional. Fifth Amendment, you know, due process. If they passed a law, for example, saying certain patents you can only collect nominal royalties, for example, that takes away part of the bundle of rights, and I'm pretty confident they'd say that's unconstitutional.
I suppose, but why? Why is that any different than what they've this is going too far afield. This is a good conversation for a different time, because, you know, like they're essentially saying that with respect to a whole host of things. Oh yeah, we know, like even in Mayo, they said, yeah, it's new. Yeah, it's not a natural law, but you know what? We're going to say it's patent ineligible because it's a natural law. Well, you don't get to say that. I mean, I know that you're the Supreme Court, right? But I mean, that would get a failing grade on every law school essay in the country. It's not this and it's not that, but we're going to say it is that and it is this. I mean, come on. Robert, thoughts on, I mean, I guess the question here is the Supreme Court likely gonna, or should they? And I think the answer you'll say is yes. And then, so maybe we can skip past that, but feel free to answer it if you want. And will they take this case regarding this situation. And maybe we're thinking about it too narrowly here, because this is an issue that comes up throughout all of government, right? I mean, that comes up in all areas. This isn't just unique to acting directors at the patent office.
Yeah, very much so. I mean, I think that the issue is significant for more cross-cutting reasons across agencies. You know, the first Arthrex case was a little different in that respect, because although that one also cross-cut across different agencies to some extent too, you know, that was a case about the ability of the agency head to overview or to oversee administrative patent judge decisions. So it was also maybe a little bit more tied to the particular structure of IPR and the review mechanisms in the agency, whereas this new Arthrex challenge, I think, is maybe a little less tethered to the specifics of the patent office, although it turns on the patent office's regulation and delegation of authority to run the agency during a vacancy. That is not that unique to the patent office. You know, as I mentioned, many other agencies have similar regulatory delegations like that. And when Congress passed the FVRA, it was legislating very much against the background of a very similar strategy that the Department of Justice had used to provide for succession in that agency by mechanisms outside what had been allowed in the statute previously. So
Say, Robert, just out of curiosity, you can stack different actings, can't you? So like once the 210 days is up, if no one's been nominated, could the president then appoint another acting?
That's a great question. I don't know what the answer is offhand.
Okay, the way I read it, it seems to just limit how long one person can serve, but it doesn't seem to. I haven't read it carefully. But yeah, one thing I do worry, if you couldn't stack actings like that, I would worry about a situation where the Senate's controlled by the other party and some organ of government, which, the Senate majority is hostile to, just refuses to confirm anyone, and you could effectively shut down the agency. But if you could just appoint another acting, I would include that.
But the opposing point of view on that, though, is that the Senate has the confirmation power for a reason, because the framers of the Constitution didn't want to give the executive branch unilateral authority just to fill the government with whichever principal officers they wanted. So, if you accept that the Senate confirmation power is designed to be a check on the ability of the executive branch to put their preferred candidates in office, then the fact that they might exercise that authority and refuse to confirm nominees because they don't approve of them is not a defect of the system so much as its intended operation.
Feature rather than a bug. I just dread to think about, given how polarized our politics have become. It's not inconceivable that the Senate would just shut down parts of the government that it didn't, whose kind of core operations it didn't like, or just out of a fit of pique. But we'll see what the Supreme Court decides.
So it does look, and there's always a risk of doing this on the fly when I'm having a conversation and listening to you guys and trying to talk. It does look like 5 USC 3346 does allow for a certain daisy chaining in certain instances of this 210 days together. Would require maybe a quiet office and some looking at the particulars. But it seems like after there's a withdrawal or return, a rejection by the Senate, the acting person can continue for no more than 210 days after such rejection. And then notwithstanding that, if there's a second nomination, the person can continue, but for no more than 210 days after the second nomination. So there may be a certain period here where you can chain these together, perhaps.
You're right, Gene. Yeah, the president could always forestall any shutdown by just actually nominating someone, and then the ball's in the Senate's court, right, Robert? And
those provisions will refer to just extending the service period of the acting officer who's currently in office. I don't think it speaks to the separate question, the interesting one Gene raised that I haven't looked into, about whether you get to restart the clock just by putting a different acting officer in office.
Well, it seems though, like if I'm reading the statute right, once someone is nominated, then the clock is suspended, right? The acting can remain in there until the Senate acts on the nomination.
Perhaps, and again, it may be for no more than 210 days. I don't know.
Well,
It's
that's
unclear.
once the Senate acts, but
Yeah, that's
you know,
true. So
I think it's A2 that says once once the nomination is yeah, you're allowed to serve during the period the nomination is pending. in
right,
the Senate.
right.
So all the president has to do is nominate someone, and you know, there's until the Senate rejects the person, there's no time limit. And presumably that B2 seems to contemplate that, of course, you can pick someone else, you know, once a nomination is rejected. And I guess, you know, it does seem, you know, the biggest problem again is just we haven't been following this statute for so long. So I think the retroactive effect of some saying now you have to follow this statute is going to give the court pause. There'll just be some worry about it. Be ready, Robert, with your arguments about you know, mitigating this, and that it's not going to, you know, cause chaos throughout the federal government. I think that's
Well, but you know, the thing is we deserve better government is what we really deserve. I mean, you know, this is just, I mean, because let's recall, it wasn't that long ago that I believe it was both parties were kind of fed up with the fact that after Director Kapos left, then we had back-to-back acting director. I think they were both acting directors, or it was Terry Ray, I believe, was acting, and I'm not sure what Michelle Lee was called, but there was like 2.5, almost 3 years of no confirmed director running the PTO.
Yeah, it's awkward. They spent a lot of time looking for someone, you know, to fill the post. I don't pretend to have a lot of insights into the Obama administration, but I heard they just, you know, not a lot of people wanted the job at that particular point. Yeah, and you know, it really, you know, to get to the kind of practical issues, it really does matter whether someone was presidentially appointed and Senate confirmed or not. There's just a lot of things that can't happen that someone in an acting role, whether under the FVRA or otherwise, can't do. You really can't launch any policy initiatives. You're in a weakened position fighting with other government departments, you know, over the agency's authority. This actually, you know, became an issue for me when I was acting. Other parts of the government decided that certain things PTO should do, they should be handling instead. And just a lot tougher to fight that battle when you're just in an acting role rather than, you know, appointed by the president and that person's guy and confirmed by the Senate.
So, Joe, was that when the FDA started rearing their head and trying to butt into what the PTO was doing? Or
you know, that's been going on for a while. That you know, that didn't come up while I was acting. We just had some tensions with the Commerce Department over administrative functions at the agency. Yeah, there's just no one there to kind of fight for the agency in these internal battles. If they were having another 101 fight and what position the government should take, for example, if you don't have a Senate confirmed agency head, it weakens their voice, especially if agencies taking a different point of view, you know, do have a presidentially appointed, you know, head of those agencies.
Mm-hmm. Yeah. So we have a question here from Ken about whether this case may wind up being different because than it would be with respect to just any other agency, because it deals with a previous Supreme Court decision in the very same case that a Senate confirmed decision maker was constitutionally required. Could that affect whether the FVRA violation is harmless? And Robert, maybe and while you think about that, perhaps could you tell us, because there are certain arguments that you made at the federal circuit that are now no longer preserved on appeal, and perhaps that might elucidate this question a little bit. Could you tell us a little bit about that?
Yeah, sure. So the Supreme Court, after it decided in the previous Arthrex case that PTAB decisions had to be reviewable by the agency head, the director, sent the case back. And as we know, when the case got back to the PTO, there was no Senate confirmed director. There was no FVRA acting appointed director. There was just the commissioner for patents performing the functions and duties of the office. And so we raised three challenges to that. The first one was a constitutional appointments clause challenge. And so the argument there was that because the Supreme Court in its prior decision had stressed the importance of having a Senate confirmed officer review decisions of all subordinates within the agency, it wasn't enough to have a inferior officer like the Commissioner for Patents review those decisions. You actually had to have someone Senate confirmed. The government's response to that argument in the Federal Circuit was that, notwithstanding what the Supreme Court said in Arthrex, it's been true for over 120 years. This decision called Eaton from the 19th century, where the Supreme Court has said that it's okay to have a temporary officer perform those principal officer functions temporarily if Congress has authorized that.
So by the way, let me interrupt you. That was the winning argument you made, by the way. And because this garbage about the Eaton stuff is, I thought that the last time the Supreme Court spoke was the most important. That was, and they said specifically what you just said, they said, and that should have been the end of the case, but it wasn't. So then that pivots the case away from that, right? From that particular issue.
Well, I mean, it depends how you read the Supreme Court's decision. If you read it as saying you have to have Senate confirmed officer review everywhere and always, then that is in some tension with Eaton, which says that it's good enough to have an inferior officer as long as it's just on a temporary basis. But the government's position and what the Federal Circuit held was that Arthrex did not overrule Eaton. Those two decisions, coexist. Mm-hmm. That was the appointments clause argument. Our second argument was the Federal Vacancies Reform Act argument. And there, you can sort of accept Eaton as a constitutional rule. You can accept the concept that an inferior officer can temporarily perform the functions of the Senate confirmed office, but the important qualification is it has to be within the bounds of what parameters Congress set on that. So if Congress says it's only these three categories of individuals who are eligible to serve as acting officers, the executive branch has to appoint someone from within those three categories. If Congress says you can only do it for so long, you can only have that person perform that temporary function for so long. And there's a certain, even though it's a statutory rule, there's a certain constitutional logic to it, because the Senate does have the power to insist on confirmation of principal officers. And so if Congress is going to cede some ground regarding that function for temporary officers to keep the government running during a presidential transition or whatnot, if Congress is going to recognize limitations on its own Senate confirmation prerogative, then it kind of makes sense that those should be observed, and that the executive shouldn't be allowed to make up its own succession plans that go beyond that. So that was the second issue. And then our third issue was a separation of powers issue that was based on the fact that Commissioner Hirschfeld had some tenure protections under the statute and some recent Supreme Court decisions saying that the heads of agencies, in order to be sufficiently accountable to the executive branch, need to be removable at will. So we made that argument as well. The Federal Circuit didn't agree with any of those arguments, and in the Supreme Court, we're pursuing the Federal Vacancies Reform Act. That, from our perspective, that's the one that is the most important of the legal issues. It's the one where there's just a clear disconnect between what the Federal Circuit held and what Congress, by all accounts, is trying to do in the statute. Like that's one where the Federal Circuit almost went out of its way to say, this is what we read the statute as saying, and we admit that if you read the statute the way we do, it's virtually toothless. Like it hardly does anything at all. So this was the question where the Federal Circuit kind of admitted it was almost reading that statute out of the US code as far as its practical impact on government goes. And so
and that was almost a quote from Judge Moore, right? She I don't think she used the word toothless, but how did she call it? It was
vanishingly small, I think was
vanishingly small.
Yeah.
So the limitations are vanishingly small,
right?
To the point where they don't really exist based on the way that they interpreted. And the reason that I get so animated about, I think I just put my finger on it, about the whole Eaton issue, is I don't see how you have to say that Eaton is overruled in order for you to realize that in Arthrex 1, the Supreme Court, they said something. They said that this constitutional officer, they fixed this problem. And that doesn't, I think, overrule Eaton for all purposes, but I think it has to be like a layer on top and be interpreted as being meaningful moving forward, certainly within at least this same or similar context. And where it irks me is that in the patent eligibility area, to just cascade for a moment, this same federal circuit has spent the last decade telling us, oh no, the Supreme Court said X, thou shalt not get this type of patent. We can't possibly try and interpret what they really meant. We can't, what they said was no, and they've even had cases where they've said that this is a top 10 medical innovation of all time. Now, whether or not you agree with that characterization of that particular innovation, that was what 2 of the 3 judges said. Okay. And they said, but sorry, the Supreme Court said this type of thing just can't get patent ineligible.
Gene, in defense
it's
of
like, for crying out loud, either you're gonna interpret the Supreme Court's decisions and tell us what they mean, or you're gonna follow them like you're blind mice, and it's the selectivity just is mind-numbing to me.
Gene, and I have to say, in defense of the Federal Circuit, I mean, they did get reversed on one-on-one issues 4 times in a 5-year period. I can understand why they're a little
okay. So, and I admit that, I get that, I understand that, but frankly, if that is your threshold, then it is time for you to turn in your black robe. Because if it was, because I live by, and look, we all have different moral codes or ethic codes, whatever. It's like, I try and live by this, is like, it's never the wrong time to do the right thing. Right. So like, I just shared with you guys, not to go too far down this rabbit hole, just shared with you guys in the green room that I made a pig-headed, stupid, rash decision about somebody that we all mutually know. And then I just told you, I want to let you know, I apologize to that person. I said I was sorry, and that happens, right? Because it's never the wrong time to do the right thing. But where does the Federal Circuit live? Do they live by that rule? No. Does the Supreme Court live by that rule? No. But they seem to expect the rest of us to. And now this is where this gets hopefully not big P political, and it can stay small P political, but that's where this starts to get frustrating to me, right? Is we need government to continue. We just, and we need people like you, Joe. We need people like you to step in between administrations. So that the next administration, you've been in the Senate, these issues, you've been in the solicitor, they trust you. Before Andre can be confirmed, they want to put somebody there that they can trust. I have absolutely no problem with that. I just wish we could all follow the rules.
Robert, just out of curiosity, I mean, the way the statute seems to read, Drew could have done, and if the statute were enforced the way you're interpreting it, Drew could have served in the exact same role for the same amount of time, right? He had the initial 7 months, and then once Vidal was nominated, there's an indefinite clock. He was there for what, like 13, 14 months?
15 months, I think. Yeah, it's 7 months plus he gets a couple extra months for the presidential transition. But when you stack them all together, I believe that's correct. I don't think there was a time limitation.
So as long as the president had appointed him,
right? That's what was missing, is that the second 2 statutory options are very explicit that the person needs to be selected by the president and only the president, and so that presumably to keep an element of accountability and make sure that is approved at the highest level, and that's what was missing, is that this succession plan within the agency was something the agency itself had decided upon. And so when Commissioner Hirschfeld took over the role, that didn't have any presidential involvement at all. So that's the respect in which there was a non-compliance with the FVRA here. But it does kind of prove our point that the FVRA's 3 statutory options are not particularly limiting. They give the executive branch plenty of options, and for if the only problem here was that the White House couldn't afford to take the time to make its own decision about who they wanted to fill that role, that's still it's still a non-compliance with the statute, in the same way that letting someone serve for 2 years in the position would be a non-compliance with the statute.
I guess what the FVRA would have cut off is the kind of post capitalist gap when
Right.
well, we went about 2 years.
It was 2.5 years, I think. And because I think Terry was there for, I think she was there for 6 months, maybe 9 months. And then I think Michelle Lee was there for about 2 years, maybe not quite 2 years.
You know, she was yeah, you know, she wasn't confirmed until after. I don't remember.
It
but
was a long,
awfully
it was a long
yeah.
time. But you know, but that, Joe, doesn't that make you, I mean, even, you know, put on your Senate hat here for a minute. I mean, wouldn't that just make you even more irritated? You know, they could have done this, it wouldn't have changed anything, and it still would have kept the checks and balances in place.
Yeah, I mean, yeah, again, like you're damaging the agency, frankly, when you don't put a Senate confirmed person in there. You know, you weaken its ability to, you know, there are just things that just inevitably need to be resolved, and it's a lot harder to do it when you're acting. You know, during just the 8 months I was there, you know, Commerce like had started to have its own ideas about things they wanted to change, and I was like, "Whoa, guys! You know, like, you know, someone's about to be confirmed. We don't know what he thinks. You know, you really can't. You know, we're forced to, you know, operate in a, you know, in stasis, and even then, you still have to. You know, we had to figure out what to do with. I think it was the SAS case, you know, when that came down, for example, and, you know, it was awkward. You know, you brief Commerce about it, but they don't really know either. And, you know, and just all kinds of other stuff, you know, positions in litigation. And
So, and this may not have been as much a problem for you because you were known, you were a pretty known quantity in DC, and you were known and well respected on the Hill. But, and not to say, and you know, Drew's a friend of mine, not to say that he's not, but one of the big functions of the person who sits in that chair is to interface with Congress, right? And it's to is to answer questions, is to be an advocate on behalf of what the administration wants to accomplish, what the agency needs to accomplish. And if you don't have that person that has that backing, or in your case, at least the relationships to leverage, that's got to be just terribly difficult.
yeah, it's not great. I mean, you know, we actually did get some legislative issues just in the time I was acting. We needed to reauthorize one of the work at home programs, TEAP. And I actually, you know, went down to the Hill and briefed, you know, briefed people on the relevant committee. Brought Andy Fale with me, you know, from
Mhm.
the patent organization who knew the history of it, and we persuaded them to. It was a relatively minor thing, but yeah, you got to go up there, and you know, when you need something, a reauthorization or an, you know, extension, and then, you know, a lot of patent legislation inevitably affects the operation of the office. It's really important to have the office actively engaged, although I have to say, like towards the end of the Bush administration, you know, the political leadership wasn't as engaged, but patent office career personnel got very involved in the development of the AIA. A lot of that work took place under Bush, and, you know, it's just people like the general counsel and members of the then, you know, BPAI were, you know, very actively involved in drafting stuff without much in the way of political oversight. Congress just you know, you want the expertise from the agency. If you expect this agency to run something, you sure as heck better talk to the people who are going to be running it and make sure that, you know, that they see it as a system that can work, for example.
Mm-hmm. So Robert, we spent a lot of time here. We're coming towards the end. We still have a little bit more time left, but we spent a lot of time talking about how having somebody who is not properly named acting within the statute, you know, kind of it creates this uncertainty, and it doesn't fit within the regulations, or not the within the statutory scheme, really. So, and we also just briefly talked about the Judge Moore's decision about how even under her reading of this act, that sort of really turns this act into a paper tiger. I mean, it's, in her words, quote unquote, the limitations are vanishingly small. So what is the government arguing here? I mean, are they saying that this is just the way it's always been? Or are they saying that the FVRA is not the only way to go about it? It's sort of like manufacturer suggested retail price. What is the argument that they're making? You know, I look at these, the three the three categories here, and I don't see a lot of room for fitting in what actually happened into that structure.
Yeah, so they, I think the government kind of has 2 points. So one is that they view an important function of this statute being a labeling exercise. So like I think their point is, if you want to be called an acting officer and use that on your business card or your office door, then you have to go through this. But as long as you are not a quote acting officer and you're just performing the functions and duties of the office, you don't need to go through this process. But I will say I don't find that convincing, because I do think when you look at the context in which Congress enacted the statute, I don't think they were just upset about the labeling. I don't think they were just upset about people using particular titles or not. I think they were trying to make a more substantive change in how far the executive branch could go in putting people in office outside the statutory parameters. The other argument the government makes is that they do see this small sliver of functions for which the statute continues to have effect, and that's in 3348. There's references to functions that are exclusive to a particular officer, and so on the government's view, if you can see that language there. It's under A1 to A2. It's functions required by statute to be performed by the applicable officer and only that officer. So that doesn't cover the vast majority of functions in the government's view, because they say that as long as the agency has general delegation authority, which virtually all agencies do, then by definition those functions are not exclusive and the statute doesn't apply. But they do see out there these like very rare instances where Congress passes a statute that specifically says here's a function and it may not be delegated to other officers, and so they would admit that for those exclusive functions you have to go the statutory route and you can't go this functions or duties route. But it's hard to, the Federal Circuit was not exaggerating when they said that as a vanishingly small category of functions. In their briefs they just filed within the past week, Smith and Nephew found one statute like that. The government found maybe 4 or 5 statutes like that, and they're just exceptionally obscure. They're
those statutes that apply specifically to the PTO or across.
No. That's the government thinks there are 0 exclusive functions within the PTO. They think that absolutely every function the director has in the PTO is a delegable, non-exclusive function. So these are 5 examples. The government was able to find 4 or 5 examples across the entire federal bureaucracy. So that puts some numbers to the Federal Circuit's claim that this is a vanishingly small application of the statute.
Yeah, so
reading that part of the government's brief, Robert, and like looking to the next page, like surely the footnote runs onto the next page. Like, no, this, I think you're right. If the Federal Circuit's interpretation is sustained, the statute has virtually no effect. Not that it's unheard of that Congress passes statutes that in the process of legislative compromise are weakened to the point where they don't really do anything. That's a common thing too.
Although this does not have the flavor of compromise. This has more of the flavor of the government interpreting the statute in a way that it might as well not have been passed in the first place. I mean,
Dean, do you remember Hayden Gregory, who used to be at the ABA, did their legislative work?
No, I can't say that I do.
He had a great line about his time on the Hill. He said they used to apply this rule that the extent to which a statute actually addresses the problems it's set out to address is inversely proportional to its odds of enactment. Meaning, like, when you get done, you kind of trade away all the things that the statute really did, and a fair amount of empty shells are passed.
That's funny. If you, I had one of my law professors. I had the great good fortune of having Carl Jorda as the professor who taught us licensing, and many of you will know he was chief patent counsel for Subagagi for many years, and he told us, he's like, when you're doing a licensing deal, you can't let specifics get in the way of doing the deal. He said, because if you nail down every specific, nobody would ever sign that contract. And that's sort of what you're talking about there is, and if you have absolutely every specific in the legislation, nobody's going to vote for it.
Yeah. The toughest decisions to make in legislative compromises are A, are you trading away the core of your bill and it's going to be a hollow shell? Or B, you see people who, resist demands for, what's 5-10% of the bill, and the whole thing blows up over it and they get nothing when they could have gotten, 90%. Those are really tough calls to make. And we'll have to see what the Supreme Court thinks about the call that was made in this case, whether did the sponsors of the FVRA, give away the game in the way they wrote it, or have the courts just been misinterpreting it?
So if you had to guess, and Robert, if you don't want to guess because you're involved and you don't want to jinx it, but I'll ask you the same question if you want to. What are the odds that the Supreme Court does take Arthrex 2 here?
Well, I think we've made a pretty persuasive case, and we certainly hope they do. I won't try and put a number on it.
So, see, and, I would agree with you. You've made a very persuasive case, and in my experience, that almost is meaningless. With the Supreme Court, at least. So, because I always tell people, as I try and do, is I try and think, what's the right thing, and then I predict the opposite whenever the Supreme Court's involved. Joe, what do you think?
I'm much more persuaded than I was initially. I have to admit, I initially, this issue first came up when I was still at the agency, and like, what's this Arthrex nonsense? Of course we could, have 3-panel rehearings, et cetera. And the more I look at it, like, the FVRA did seem to try to deal with this exact problem. The whole Eaton issue is basically resolved by this. Whatever Eaton meant by temporary, this statute defines it. And I have to agree, the current interpretation, although it seems to have been adopted by all the courts of appeals, it really does, gut the statute. I just think a big part of the Supreme Court's concern will be, what's the blowback going to be if we start to enforce this statute all of a sudden? It's one thing to say prospectively, like, from now on you have to do this, but how much past government activity are you calling into doubt, if you suddenly start to enforce the statute?
Yeah, I don't know. It feels like it is an argument that the conservative wing would be interested in, if what we hear is correct, that they do want to say something increasingly more about the administrative state, and checks and balances. This presents it all. I don't know. I mean, because there seems to be a clear answer here, but the last time I thought there was a clear answer, the Supreme Court in a patent case then decided that, well, stare decisis is far too important, and we just need to continue to go along with the wrong rule because it's certain, and I have no idea. I mean, I think that it would be better form of government to have people who are acting, to have it done properly, to have the statutes have meaning, and to get people in these roles quicker, sooner rather than later.
Yeah, definitely. I mean, they would have had to, I forget exactly when Vidal was nominated, but it definitely pushed up against the time limits.
Yeah, because I know we're going long here, but the thing that winds up being really frustrating for me is that when you look at this, because I think Kathy Vidal didn't get in there until more than well, Drew was there for 15 months, so she didn't. It was 15 months, right? So at that point, assuming she stays until the end, and I'm not saying I know anything, I'm just saying, okay, assuming she stays to the end, you almost don't have any time to do any kind of meaningful rulemaking. I mean, certainly not a big rulemaking package. You have time to make some small adjustments around the edges, because if there's a big rulemaking, people know how to stop those. They know how to slow them down. They know how to muck them up. And if you're not going to get a second term, it can be really tough to do anything of consequence. And if you're getting later and later and later, then that's not a recipe for doing anything of consequence to fix systems and just.
Ian, you've gone want mute briefly. Still lost you.
We still cannot hear you, Jean. Not sure what's going on.
Okay, I don't know what's going
Oh,
on.
there it is. Now you're back.
Okay, because it was the microphone was bouncing on my end. Maybe I was just talking too fast. But in any event, we're kind of running late, and so we should probably wrap this up anyway. So let me give each of you one final opportunity to give your final thoughts. Joe first, then Robert, I'll give you the final word.
I just say, even if the government's interpretation of this is right, is sustained, something like the FVRA ought to be the law. You ought to have some outward boundaries in there as to how long an administration can delay in appointing people for these important positions.
Yeah,
Yeah,
great.
and
Thanks for being here.
I'll just add, I think Joe made the point earlier that at the end of the day, it's desirable and good to have people that have been confirmed by the Senate running these agencies. And so what we're really talking about in this case is kind of the interstices. I mean, what do you, to the extent you're going to derogate from that, it should be kind of the exception should be well defined and not open-ended. And so that, this court is kind of about how much you're going to give and whether you're going to give more than Congress prescribed to have an alternative mechanism of allowing inferior officers to exercise those important agency functions. I think we've set our case forth pretty clearly in our papers, and I hope we get the opportunity to present it on the merits to the Supreme Court.
Great. Well, thank you guys very much. I really appreciate you both being here. Joe, always fun to joust with you. And Robert, it was good to have you here to explain your case. And like Joe, I think you've certainly opened my eyes a lot more, and hopefully you open others' eyes as well. And good luck to you. And we'll be following along and see what the Supreme Court does.
Thank you, Gene.
And that's all we have for today, everyone. We'll talk to you soon. But bye for now.